series of Senate files. We will take them up in the following order. We will take up Senate File 40 first. Then we will take up Senate File 102. And if time permits, we will take up Senate File 68. With that, committee, let's look at Senate File 40, Criminal Record Dissemination Military Department. We are joined by the Vice Chairman of Transportation. Welcome to the Judiciary Committee. So thankful to have our transportation friends here.
Thank you very much, Mr. Chairman. Members of the committee, I bring to you Senate File number 40, Criminal Record Dissemination Military Department, sponsored by the Joint Transportation, Highway, and Military Affairs Interim Committee. This act relates to criminal procedure authorizing the release of military member criminal history, record information as specified, and requiring military member fingerprinting as specified. Before I get into the body of the bill, I think it's always important, and it's something that a lot of us lose with regard to electronic information. So
Chairman.
Access to and dissemination.
Yes, can we get him to speak closer to the mic? Thank you, Representative.
I am a little bit soft-spoken, I understand that. So when you start talking about the agencies that have access to criminal information, it's not just one agency. It covers a broad gamut, and that includes Family Services, Statistical Research, Department of Health, Department of Nursing, Secretary of State, because they have to check whether or not somebody may have a felony before they can vote. Goes on, talks about public departments, Homeland Security, Military Department, which we will talk about, real estate appraisers, physical therapy, the FBI, other state agencies. So these records are very important. There are a lot of people that have access to them. And there is protection. If you look in the back portion of the statute, there is protection. And I would just say parenthetically, that may be a good interim topic. You know, as electronic records become more and more widespread, it may be more important to look at that to determine who is the custodian of the records once they've been transferred and how they're handled once they've been transferred. But that's a little off the topic of this particular bill. So this particular bill is talking about the military department. Right now, the military department has authorization to receive information with regard to new employees, and also many agencies have been sharing that information voluntarily. What this bill does is it allows them to gain information without having to go through the voluntary portion of it. It says shall share the information. It also talks about current members. It also talks about whether or not that information is involved in a completed investigation. They're not looking at investigations that are undergoing but completed investigations. And that, you know, is always a policy, always kind of a policy question. There are completed investigations that become public information. There are other completed investigations, obviously, maybe if it involves a minor or something like that, that may be sealed. And so, you know, those are some questions. But what this bill is doing is asking in a broad gamut for those agencies to participate and to share that information. It's important for our Guard and for our military members to have that. They are dealing with people who are being deployed. They are dealing with children. There are just a wide gamut of reasons why that information is important to them. So that, in a nutshell, is the bill. It also goes on to talk about fingerprint records and make sure that they are able to receive the fingerprint records, and that's 719-201. So with that, Mr. Chairman, I would stand for questions.
Committee? Representative Zwanitzer.
Thank you, Mr. Chairman. Any discussion on what our good friends down the hall did in regards to page 2? I'm not sure if Representative McGuire's the right one, or I can ask the military department at the appropriate time if Representative McGuire doesn't want that question.
Vice Chairman McGuire.
Thank you. And unfortunately, I don't know very much more than what I can see here has been amended by the Senate. So
Vice Chairman Washington.
Thank you, Mr. Chairman. I just want to verify that over the interim, when your committee was working this bill, that the Wyoming division that handles these sorts of records was participant in some of those deliberations over the interim, or were they at least informed about any of these changes?
You can state the name in committee, Vice Chairman Washington.
Did DCI participate in your deliberations over the summer to any extent?
Vice Chairman McGuire.
I don't know if DCI in particular participated, so I don't have an answer to that.
Representative Craigo.
Thank you, Mr. Chairman. Representative McGuire, I just have a question on page 2, line 16, and you reference this in your testimony, the words completed investigation, and sort of have a little bit of concern about that, and at what point local law enforcement shall be required to disseminate documents related or interviews, et cetera, related to their investigation. And I'm pretty sure we're not trying to interfere with the investigation, but there's a difference between the investigation being completed by law enforcement and the case being closed. Between that period of time when law enforcement says we've completed the investigation and then it goes to the prosecutors, where are we talking? And we may just have to get together and figure out some language to clean that up on the floor. I don't know. I don't have anything in mind today, but causes me a little bit of concern. Do you have any thoughts on that?
Vice Chairman McGuire.
Thank you, Mr. Chairman. I do know that that was discussed, and specifically, the military department did not want to interfere or even be a part of any ongoing investigation. So specifically, the language was completed investigation, so that it would be done. There again, at that point, it covers kind of a gamut of things, and you can go anywhere from an investigation that is completed in public record to, again, some sealed records. And there are specific statutes that deal with sealed records and everything. And quite frankly, I don't have those in front of me, so I can't tell you any more than that.
Committee. All right. Thank you. Anything else, Vice Chairman McGuire?
No, thank you, Mr. Chairman.
All right, excellent. Then we'll bring up the military and your attorney's online. So you don't need Mr. Smith then. Can you admit, Mr. Smith, please, Carol? Welcome, General.
Hey, thank you, Mr. Chairman. Thank you for the opportunity of being here twice in 2 days. Members of the committee, Mr. Chairman, for the record, my name is Major General Greg Porter, and I serve as the Adjutant General for the state of Wyoming. I wanted to provide a little context as we go through that on why are we here. So this is an interim topic that happened late in the interim, and it really spun out as a result of the voluntary sexual harassment, sexual assault report we provided to the governor and the committee. Out of that report, the committee was very interested in saying, hey, how can we help you prevent sexual assault and sexual harassment in the future and help get after that problem set? So there were 3 bills that came out of that. The first one was making this voluntary report that we did mandatory. That's Senate File 45. It's going on today. Secondly, was providing access to workforce services to help with investigations and counseling for EEO matters, and also establishing an Article 138 process. The third bill was this bill here, which really got after expanding the ability for the Wyoming Military Department to have criminal records above what they currently have. Right now, we only are able to look at new employees to be able to do that. This would let us look at current employees, but we're pretty much restricted into a couple of areas: security clearance decisions, mobilization decisions, and training, that sort of thing. Why that's important is, if you look particularly on the Army side, if somebody is accused, in this case, we were looking at sexual assaults. because oftentimes those take a very long time to prosecute. There's a low prosecution rate on the civilian side. What happens on the Army side is if you're accused of such a crime, you have a suspension of favorable action placed against you, what we call a flag, which means you cannot be promoted, you cannot deploy, you cannot go train, you cannot receive awards, you cannot do any of these things. So what that started to cause is once the investigation was completed by law enforcement and then turned over to local law enforcement, county attorneys, it would often take months and sometimes even years for them to make a decision about whether they were going to prosecute the case or not. In the meantime, our service members would sort of languish in that they can't go do anything. And so what we were trying to be able to do here is take a look at that investigation and say, hey, does the adjutant general would it be prudent? Would it be a good decision to lift that flag and allow them to go get training or deploy or do those things? Or is there enough in that investigation to warrant not to do that? So what we don't want is be able to promote people that ultimately should be punished. So that's sort of the context that came out of this, out of the interim, and why Joint Transportation and Military Affairs had it. And I think I will stop there, Mr. Chairman, and then answer any questions, and then turn it over to Major Hinkle for some of the details and maybe answer some of the questions that were previously asked.
Welcome, Counselor.
Thank you, Mr. Chairman. For the record, my name is Major Karen Hinkle. I'm the Staff Judge Advocate for the 153rd Airlift Wing, which is part of the Wyoming Military Department. I think perhaps the best way to go about this, and I think we had a really good introduction of the summary of the bill, and I think you've got a good understanding of the purpose of it. I have some notes on some of the earlier questions, if I may. Representative Washut, your question regarding whether DCI was consulted, and they were initially consulted in the interim stage, and so they didn't participate in those interim hearings, but they were consulted in the process of coming up with this bill, and they were satisfied. And then Representative Craigo, back to your question about why the language of completed, and this has been the subject of some discussion both in the interim sessions and I think on the Senate floor. Different agencies view the word complete in a different way. And the intent for us is not to take over an investigation or to interfere with it or to interfere with a resulting prosecution if that's the way for it to go. But we want to ensure that we have access to those files once they are complete so that we can take the necessary follow-on actions. To that end, the amendment that I believe it was Senator Nethercott proposed was really reflected at the end of paragraph 15, and that's lines 13 through 19 on page 2. And I think that was her version of how to address to better address the completeness of the file. There may be other ways to do that, but the intent is to try to work with the different law enforcement agencies that might be involved, the different stages of investigations and so on. Pending any questions.
Representative Zwanitzer.
Thanks, Mr. Chairman. I just have real concern on page 2 on line 18, when that information shall grant the right of inspection to the military department. So the way I read that, and I'm checking if this is how you read it, the local law enforcement entity doesn't have a choice, that if you ask for that, they're required by law to turn it over to you. Does that cause you any concerns?
Major Hinkle.
Mr. Chairman, Representative Zwanitzer, I do read it the same way. Anytime you have shall, it's a pretty obligatory requirement. I don't necessarily have concerns with that. At some point, we are going to need to obtain those records. The current process that we have is fairly clunky because depending on how familiar that law enforcement agency is with the military department, it can take some phone calls and working with the county or the district attorney, depending on who's involved. Again, I think that any concern would be limited by the fact that it has to be the completed investigation file. So the intent there is to not concern the law enforcement agency about us attempting to either take over, which we can't. We don't really have investigatory capabilities in civilian law enforcement, but to just ensure that once we look for those files, it's just the completed records after they have closed out their investigative process.
Follow-up, Representative Zwanitzer.
So then maybe my concern is when it says criminal, thank you, Mr. Chairman, criminal history record information. So said person gets an investigation, they are exonerated, even if rumors and accusations are still swirling, would you agree that they don't have a criminal history record if they were exonerated? Or do they only have a criminal history record if something was in fact, prosecuted and charged, et cetera? My question is, can you ask for information in a case that never actually became criminal because the charges were not filed? And I'm trying to figure out where in that point I feel you should have access to information, even if there's still accusations out there. And thoughts on that, if it's only criminal history, if they've committed a criminal act in a court of law? Thoughts?
Counselor?
Mr. Chairman and Representatives Wanitzer. So that really kind of gets at the heart of the matter. We have had several cases where, due to perceived evidentiary issues on the part of the district attorneys, cases have not been put forward for criminal trial. What makes that difficult for us is that we have both criminal and administrative processes that look at misconduct. And really and when we're thinking about the administrative processes, we're looking at whether military members should continue to serve as a member of the armed forces and be placed in situations of great trust, either as we'll use the word employee, but as a military member, and also potentially with respect to their security clearances, because all of those things are very tied together. We have obtained files from members who have been investigated for misconduct, which ultimately did not result in a trial. The charges were dismissed for various reasons. And we have gone through administrative processes and used the files and the investigations, and then concluded additional investigation when necessary, and to the extent that we can, to follow on and appropriate administrative actions. So that is a purpose for us, potentially.
Representative Oakley?
Thank you, Mr. Chair. And thank you, Council, for being here. So if what I'm hearing, that specifically that completed investigation part is, largely that would apply to where charges were not brought due to the attorney that could bring charges feeling that there's not enough evidence to sustain beyond a reasonable doubt a criminal conviction. So what we're looking at here is then you taking that same, then applying an administrative standard, a lower standard. But so using that criminal investigation information that specifically didn't hit beyond a reasonable doubt, but being able to use it for a lower standard, and using it for those purposes. Is that really what we're looking at here?
Major Hinkle?
Mr. Chairman and Representative Oakley, yes, you're correct. And so to give you a little bit of an understanding too about what that administrative process looks like for us, it for the lack of a better term, it looks kind of like a trial, but the standard of proof is different. So with your administrative hearings, it's a preponderance of the evidence, more likely than not, which is admittedly a much lower standard than your criminal trial. But at the end of the day, we are also looking at an employment decision and whether or not somebody should be entitled to veterans benefits, as opposed to being incarcerated or being subjected to other typical criminal penalties. These are, when we are depending on the status of the member, how long they've been in service, and on the kind of characterization that we're looking for their service. These tend to be board hearings, which again means that the member has an opportunity to respond, to present evidence in rebuttal. We're usually required to call the witnesses or at least provide statements from them. And then we have a panel of independent military members who review the case and make a decision based on rules and other formalities.
Representatives Wanitzer?
Thank you, Mr. Chairman. So would it be fair to say, or has it happened where you got materials from an investigative agency, no charges were filed in that case, no prosecution, but with that information, as you mentioned in some of these cases, you still use that to make a negative determination on someone's continued employment, or even if a criminal trial wasn't warranted, or you still took that information and there was a negative consequence to the employee for that information? Has that happened, or that could happen?
Counselor?
Mr. Chairman, Representatives Wanitzer, yes, that is possible. And so the conduct at issue. Again, we're not looking to, it's interesting, right? Because we do have the ability to conduct criminal proceedings. The intent is not to usurp the typical criminal jurisdiction. And so in cases where those have gone forward to a district attorney and the district attorney has reviewed the case, what we do is we ask for the evidence file to determine if there's something that we need to take action on. And it's not an intent to confuse or conflict with the ruling, but it's kind of like the difference between a civil trial for issues that come out of a criminal case versus a criminal trial. So you see the same kind of thing in the civilian world all the time, where maybe somebody suffered an injury, there's not enough quite there to get them to a criminal outcome, but they still have a civil suit that could follow. And essentially the military is just asking permission to get the record so that they can make an appropriate employment determination and other follow-on factors.
Representative Oakley.
Thank you, Mr. Chair. So, on balance, I can see that, the criminal standard and the punishment very significant attached with that versus employment and a preponderance standard. But since we are talking about criminal conduct, my question is, in those hearings, are they asked to testify? Because what are your thoughts on Fifth Amendment concerns? Because at the end of the day, completed investigation does not mean, in the criminal realm, does not mean that more investigation can not be done and charges brought. So while I like the idea, I know you guys are trying to get specifically at sexual assault cases, very difficult cases. The old, he said, she said is difficult, but is he going to say? I mean, it could be either way in this case, because I don't see how he would, assuming it's a he, will use he in this instance in my scenario, where it wouldn't affect his rights if he didn't testify as it comes to this military, and it could affect his rights if he does. Any comment as to that?
Counselor.
Mr. Chairman, Representative Oakley, we absolutely observe the respondent, and we call them a respondent. So somebody who is subject to one of these proceedings is a respondent. They absolutely have the right to the Fifth Amendment. So they can choose to make statements. They can choose to remain silent. If they remain silent, that cannot be inferred adversely against them by members of the board. The hearings are presided over by an experienced attorney who serves as the legal advisor and gives the board members rules and instructions on how they are to consider evidence, what evidence is admissible, and that includes instructions as applicable to how the respondent has chosen to make a statement or not. They can testify under oath. They can make unsworn statements, so they can't be cross-examined. It's really a very deliberate, thorough process, and in terms of ensuring due process, I will say I think the military's process is really pretty fantastic. And I've had the opportunity to serve as for lack of a better word, a prosecutor. We call it the government representative. I've also served as respondents counsel for about 3 years. And so it really, that is a choice and a strategy call that the respondent can make with their counsel. And they are also offered the opportunity to consult with experienced military counsel to represent them, or they can hire a civilian counsel of their own choosing. So it's a process that's really got a lot of due process built into it and a lot of procedural safeguards to ensure that military members have a fair hearing, that the evidence is as fully developed as it possibly can be, and that an appropriate and just outcome is reached. And I will tell you as well that we've done, off the top of my head, probably 7 or 8 or more of those hearings in the 4 years that I've been part of the Guard. And we sometimes have people that are discharged, and we sometimes have people that are retained. And so just because they're going through a hearing, it is not a foregone conclusion. It is not just sort of a, the military is doing this process to make it look like we're being fair. The members are very deliberative and very cautious in ensuring that they reach the right conclusion.
Anything else, General?
Mr. Chairman, I don't believe so at this time. Does the committee has any more questions?
Okay. Well, and I'm going to guess you covered what Mr. Smith probably doesn't have anything.
He may,
to add.
sir.
Mr. Smith? Welcome.
Thank you, Mr. Chairman. I just wanted to mention kind of going back to Representative Swanser's question, the existing statute 719-106 currently says criminal history information shall be disseminated. So that shall is in the current statute. I also just wanted to bring the committee's attention to the fact that this current statute does not restrict the use of that information to agencies such as the Department of Health, Department of Audit, the state auditor, the state treasurer, without restriction, the Wyoming retirement system. So actually this bill is tighter in a sense of the uses that we in the military department could use than the existing statute for those other agencies. I just wanted to provide that. It's sometimes when you look at these bills out of the context of the existing statute, you kind of miss that nuance. So that's all I wanted to provide to the committee, Mr. Chairman.
Thank you, Mr. Smith. All right, we'll move to general public comment. Do we have anyone in our virtual world who's signed up to testify on this bill? Raise your little hand if you are, and Carol will admit you. In the 1 second, Mr. Winnie, please. In the in-person world, raise your hand if you're going to testify on this bill. Mr. Winnie, you're the lucky winner. Come on up.
Mr. Chairman, Bill Winnie, Sublette County. I don't know if I'd characterize myself as a lucky winner, but I do have some experience that may shed some light. Representative Wanitzer asked a question about what they did at the other end of the hall. They worked over the fingerprint issue quite extensively as to why you have to repeatedly take fingerprints. And I got up and spoke to that, and based on that security clearances I had over the years, it's a way of making sure you're still looking at the same person. Admittedly a long shot, but the other thing is the general talked about flagging records and looking at their members. I had the experience of being a court-martial member twice on trials of very serious nature that could have been prosecuted in the civilian world. The events happened out off of a military installation, and the civilian authorities refused to go after it. Now, in the military, you have authority over the person. So wherever the person is, you have authority over them regardless. So you don't have to have authority over the place. So when they came back into the military, that's how the charges ended up getting preferred. Both were not guilty. And so there's the kind of thing that the general was kind of working through there. Is what do? Can we look at the records? Can we form an opinion? Can we deploy the guy, et cetera? The other thing is you had the question, I believe it was Representative Oakley, about the standards applied in administrative hearings, Article 15. I was an Article 15 hearing officer twice, 2 times a commanding officer. Probably heard something like 600 or 700 cases during my time. All I can tell you, Mr. Chairman, Representative Oakley, is I applied the rules as they exist. I did not use lower standards. And I suspect most Article 15 officers did, but that's what I applied. So at the end of the day, I hope that gives you a little bit of illumination as to what the general was trying to work through. Subject to any questions, thank you very much.
Committee questions for Mr. Winnie? Thank you, Mr. Winnie. Carol, did anyone raise their hand? All right, anyone in this room wishing to testify on this bill? I'll close public comment on the bill. Committee, what is your pleasure? Move the bill. Senate File 40 moved by Vice Chairman Washit, seconded by Representative Rodriguez Williams. The amendments on this bill?
Mr. Chairman,
Representative Wanitzer?
I do have an amendment.
Okay.
And probably the easiest way to state it is to delete all of the Senate amendment language and take it back to the white copy you have in front of you. It basically deletes lines 14 through 19 on page 2. And it also deletes the words.
Is there a second on that
Complete
amendment?
investigation line, page 3.
seconded by Representative Craigo and moved by Representatives Wanitzer to delete the Senate amendment. There was only one Senate amendment. So everyone, Carol, that makes sense for your bookkeeping? And does the committee understand the amendment? Do you have discussion on this amendment? Would you like to further discuss it, Representative Wanitzer?
Mr. Chairman, it was just along the lines of my concerns previously brought up on obtaining records of completed investigations that may or may not. I can appreciate why they want it. I just have real concerns when they shall grant the right of inspection, and not that they would use it for abusive purposes, but I just think it needs to be tighter and go back to the original bill that was agreed on in interim.
Representative Rodriguez-Williams?
Thank you, Mr. Chairman. I'll be on no on the amendment. I appreciate the Senate's addition to it and clarification, and I think there's a definite need for the information. And I support the language.
All right, further discussion on this amendment? Sensing you are ready, question being called. All those in favor of the amendment signify by saying aye.
Aye.
All those opposed?
No.
That amendment is adopted. Additional amendments on this bill? Division? All those in favor of the amendment signify by raising your hand. Okay, all those opposed? Like I said, this amendment is adopted. Further amendments on this bill? Further discussion on this bill? All right. Carol, will you please do a roll call vote on Senate File 40 Criminal Record Dissemination Military Department?
Representative Craigo.
Aye.
Representative Larson. Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez-Williams.
Aye.
Vice Chair Washit.
Aye.
Representative Yen.
Aye.
Representative Wanitzer. Chairman Olson.
Aye.
9 ayes with amendment.
Vice Chairman McGuire, I assume you'll help us floor manage this bill since it is a transportation bill. All right, thank you. All right, folks, we will move on to our next order of business. Senate File 102. We have the sponsor of this bill, Senator Hicks. Welcome to the House Judiciary Committee.
Thank you, Mr. Chairman. Mr. Chairman. Inadvertently do not copy this. I'm going to give one to your secretary if I could borrow one.
Yep, I have a digital version, so.
So, Mr. Chairman, I'll take some guidance from you. This is how you would like me to proceed on Senate File 102. I don't have the opportunity to sit before this committee very often. But would you like me to walk through the engrossed version or walk through the engrossed version and tell you what the changes were between the original bill? So, Mr. Chairman, just some guidance from you on how you'd like to proceed with that.
Senator, I do think that would be helpful if you, you can take that presentation up however you'd like, but definitely highlighting whatever differences are between the original bill and the engrossed would be helpful. And
all right.
And the floor is yours.
So, Mr. Chairman, as I present the bill, but members of the committee, first, I would like to just give you a little bit of background. This is a culmination of about 5 or 6 months worth of work, working with members of the legislature, working with our local law enforcement communities, and then also working with pro-amendment, Second Amendment groups here in the state of Wyoming, Mr. Chairman. So that gives you a little bit of background. significant amount of effort has gone into this, back and forth with law enforcement, different organizations and members of the legislature, trying to find what we could actually craft in the state of Wyoming that met all the legal and constitutional tests, but still afforded protections for both our citizens and our law enforcement under the Second Amendment, and then the implementation of that. So, Mr. Chairman, I'll just walk you through the bill. It's actually fairly simple. If I can find my glasses. Oh, there they are. Imagine that. So, Mr. Chairman, the real meat of the bill starts on page 2. If we just go down to section 914-202, it creates 2 new sections in our statutory provisions. This gets into the declaration. This is the authority that the state of Wyoming has in adopting this legislation. So obviously, we're going to do it on behalf of the Second Amendment. And then we call out the 10th Amendment to the United States Constitution. But I think the linchpin of this stuff is what you typically don't see in a statutory reference is down on line 14, Prince versus the United States, 521 U.S. 898. That was a Supreme Court case that dealt specifically with the Brady Act, which was a gun control measure passed by Congress. And as part of that Supreme Court ruling, has become what's known as the Anti-Commandeering Doctrine. And there's been more than 5 or 6 of these Supreme Court rulings over the years. This was the 4th one that the Supreme Court ruled on. And it really serves for the linchpin under the Anti-Commandeering Doctrine. And basically I'll give you the real quick version of the Prince versus United States, was a requirement was passed as part of the Brady Act that local sheriffs would have to go out there and actually register guns. And so there was a lawsuit that inspired, went all the way to the Supreme Court. Chief Justice Scalia wrote the majority opinion of that and says federal government's more than entitled to write laws and regulations. But what you can't then do is force the states to implement a federal law. And that becomes the linchpin or the idea behind anti-commandeering doctrine, that the federal government can come in here and do that. But they can't hijack the state of Wyoming and say, now you're going to enforce something. And particularly what they said, it's unconstitutional to do that. It gets back to our 10th Amendment right as a state. And so that become the linchpin underneath that decision. So, Mr. Chairman, that's a little bit different, but that's where we come in and say, now, this bill has been tried to narrowly construct the ability to meet that test. And so if we just get into the meat of the bill, Mr. Chairman, so we create the new section 914-203, and then if you flip over, this is the bill with a few carve outs in subsection B, but in subsection A, it says just all political subdivisions of the state are prohibited from using any personnel funds appropriated by the legislature or other source of funds that originate within the state of Wyoming to enforce, administer, or cooperate with any unconstitutional act, law, treaty, executive order, rule, regulation of the United States government that infringes or impedes on the free exercise or individual rights, the Second Amendment of the Constitution. Mr. Chairman, that's the bill. Now, we do bring in a couple of exceptions under B, not necessarily, I would say exceptions, but clarifications. And so we certainly want to make sure that our law enforcement has the ability to work with our federal counterparts on task force or other criminal activities that may be going on in the state. So we bring in this additional language that nothing in this act shall limit or restrict public officer to provide assistance. And then if we get down on 17, nothing in this act will be construed to prohibit Wyoming government entities from accepting federal aid. And then, Mr. Chairman, subsection C just brings in a penalty component. So with that, Mr. Chairman, what I will do now is walk you through the difference between the original version and the engrossed version. So the first thing you find is on page 3, line 7. We actually included the word unconstitutional act to make that clear that it would have to be something that violates the Constitution. It would be adopted pursuant to a judicial order, law, or treaty. The other thing, or not a judicial or executive order. So the other thing on line 7, after the word treaty, the original bill had judicial or executive order. So we have struck the word judicial out of there. And the reason we did that, Mr. Chairman, after going through a legal review of that, we certainly didn't want to run afoul of the separation of powers issue and tell that the judiciary that we were going to basically reject this under a 10th Amendment challenge. So we removed judicial from there. Mr. Chairman, if you go down to line 3, page 22, after who, we inserted knowingly. And so now the penalty would only apply not to somebody that was inadvertently committed this act, but somebody that would knowingly committed this. And I think that's a very important, particularly legal concept. They have to know they're creating or perpetrating a criminal act, because and the complications of a lot of these task forces and other areas, it could very easily, somebody could inadvertently do this. And so we don't want to capture good guys that accidentally did something wrong. And so that's the concept behind bringing in the knowingly component. And Mr. Chairman, those are the only changes that the Senate did to get to the engrossed version. Mr. Chairman, I don't know what the pleasure of the committee is at this point in time. I do have a proposed amendment to the bill. If you would like, I could discuss that at this point in time.
Senator, yes, please. As you were on page 3 reading subsection B, I noticed you said public officer, which is your amendment to line 14 as I pen it in, but would you please go ahead and discuss that amendment now?
Yeah, Mr. Chairman. So the two amendments that are proposed were basically cleanups. And so we had outside legal review of the bill, and then we also had our LSO as the engrossed version go back through a legal analysis. And it was interesting that both of them flagged the same 2 areas. And so the first one is if you go through the whole green books and you look at that, we bring in the concept of a public officer instead of a public servant. Public servant is much, much more broader. It brings in jurists and other entities in there. So that's just to clean up to get to the people that would most likely be enforcing or under jeopardy. So we bring that in and we just change that from 65101A6 to 65101A5. So that's a cleanup that moves it in those 2 places from a public servant to a public officer. Mr. Chairman, the only other one is if we get to page 4, and this will require a little bit of explanation. And you on the Judiciary Committee are very familiar that in our statutory constructs, we often reference other provisions and statutes. That's normal. But because we referenced in this provision that the penalty for violating this act would be the same penalty under the Wyoming Firearms Freedom Act, it seems to be that there's a number of people in the public and even a couple of people in the Senate that can't follow the statutory construct. It just says it's the same penalty. So consequently, just to make it clear, rather than by reference, we're actually just bringing in the exact language. And so just to clean that up, to make it explicitly clear what the penalty is for that. Doesn't change anything in the bill. It just, rather than referencing the penalty, it just says this is the penalty. So it's consistent with the bill. It's just a change in statutory construct for people to be able to easily understand what the bill does. So with that, Mr. Chairman, that is the proposed amendment, and I would stand for any questions on the amendment.
Senator, you underestimate the House's ability to read and compare the statute.
Mr. Chairman, I have never underestimated the Houses, but we seem to have at least 1 or 2 individuals on the Senate side that are having a real problem with the statutory construct there. So I think it just deflects some of the artificial criticism associated with the bill.
Vice Chairman Washit, you had a question?
Not to the amendment, so I'll hold for later.
You can speak. You can, if you have a question about the bill, on the bill as a whole.
Thank you. Senator, your comments about inadvertently violating, I just want to run a scenario by, and I think we're on the same page. An officer commits an act on May 1st. July 1st, the US Supreme Court or the Wyoming Supreme Court defines that same conduct as now being unconstitutional. But on May 1st, when the officer committed that act, the officer best understanding of the law at that time was that it was constitutional. So later, a few months down the road, the Supreme Court says that's unconstitutional. Do you understand this language on subparagraph C on page 3 to be a shield for that officer who didn't have a crystal ball, couldn't see what the Supreme Court was going to do down the road, but was following best understanding of what was and was not constitutional on the day the officer took the action? Is that scenario fit with what you were trying to accomplish here?
Vice President Hicks.
So, Mr. Chairman, I would always be dangerous to try to tell you what the law says, not being a law. I can make my own interpretation, but I do understand the fact that we can't write ex post facto laws. I think the scenario that Representative Washut paints would be an ex post facto penalty that at the time that action happened, it was still perfectly legal. So even if we adopted this law and it became effective July 1st, it really has no implications, as I understand the whole concept of ex post facto being able to reach back and change what the law was on May 1st. And so, again, I'm always treading on thin ice when I delve into the legal, but that's my understanding of the way it would work. I would defer to some of the other experts that you may have on your own committee, but I'm pretty sure that's how it would work, Mr. Chairman.
Committee, Representative Yin.
Mr. Chairman, thank you. Vice President Hicks. So the question of unconstitutional that your members added on the other side, I guess my question is who decides what is unconstitutional? Because for example, I make arguments on the floor that certain things that we're doing is unconstitutional, but the body as a whole has chosen it is constitutional. When enforcing subsection A, who decides whether the public officer is knowingly violating something that is or is not unconstitutional? What does that mean? Thank you, Mr. Chairman.
Vice President Hicks.
So, Mr. Chairman, I think probably the best illustration that I can give you is just what we went through with a series of mandates that come out of Washington associated with vaccine mandates. And so the ultimate answer to your question is the courts will decide what's constitutional or not. And as that process unveils itself, the states can appeal that. So the states can certainly come in and with the exact same scenario that we see. And so let's assume that scenario would happen. So who determines what's constitutional? Well, the remedy for that is to work through our legal process. No different than we just experienced. And so the states very well may be the first bastion to make that legal question is whether it's constitutional or not. So the ultimate decision of that would reside with the Supreme Court of the United States if it went that far. But you may have a series of state federal courts, state Supreme Courts. So it's a legal question, right? But I think we have a very close scenario that we just went through this thing. And I would assume that there would be a very similar process. You would have a number of states that would object to any executive order or rule or anything that would infringe upon those Second Amendment rights. So I hope that answers your question, but certainly that's the legal process as to how to answer that question.
Representative Yin, follow up.
Yes, Mr. Chairman, thank you. So to follow up on that, Mr. Chairman, then I guess I'm confused on why we need this bill in the first place, because if the court has decided that it's unconstitutional, wouldn't someone trying to enforce an unconstitutional act already be violating the law? I'm trying to understand the whole purpose of why we need this bill and codifying a test that the Supreme Court has done. Should we do that for every test that Supreme Court has in a ruling? Mr. Chairman, thank you.
Vice President Hicks.
Yeah, Mr. Chairman, I think the answer to your question is because it's very important to the citizens of the state of Wyoming. And I think it also sends a message because under the scenario that we just described, while a citizen could make a suit as an infringement on a Second Amendment, this provides guidance to our Attorney General under our laws to go ahead, if there's a determination of unconstitutionality, that the state would intervene on behalf of those citizens. So I think it's very important that we have that statutory guidelines in there.
Committee, Representative Provenza.
Thank you, Mr. Chairman. Vice President Hicks, on page 3 of subsection B, it talks about that nothing in this act shall be construed to prohibit Wyoming government entities from accepting federal funds. So if it then puts us in a position where the federal funding is going to be withheld, what happens there, I guess, or maybe I should better frame my question. Is there an instance, or did you hear testimony that perhaps maybe the Department of Justice would withhold funds from the Attorney General who divvies out money to law enforcement here if we decide to do something that is not in line with the federal law or orders?
Vice President Hicks.
Yeah, Mr. Chairman, I'm not inclined to hypothesize about what may or may not happen in the future. I think that's speculative. So I don't know what would happen because it hasn't happened. And so I think anything would just be a shot in the dark. So I don't know that answers the question, but the answer to the question is until that happens, I don't know there's an answer to the question.
Representative Lawson.
Thank you, Mr. Chairman. Do you see a difference when maybe the gun or the accessory that may be not meeting executive order or such? Would there be a difference if it was built inside the state or outside the state in your bill?
Vice President Hicks.
Mr. Chairman, it would make no difference whatsoever. The test here is whether it's constitutional or not. That's the test. And so this has nothing to do whether it's manufactured inside or outside of the state. It has to come to the simple fact is if there is a rule or executive order or law that's unconstitutional, whether it's accessories or magazine capacities or whatever, that becomes back to the constitutionality. That's what this bill speaks to. Mr. Chairman, I hope that answers the question of Representative Larson's.
Representative Larson, you good? Committee? All right. Anything else?
No, Mr.
President
Chairman.
Hicks?
I'll sit here, and if there's additional questions and I can provide some edification to the committee, I would be more than happy to do so. Thank you.
We would appreciate that. Are there any government agencies wishing to testify on this bill? Are there any government agencies registered online? Carol?
The only person right now with their hands raised, I have Alan Thompson and Aaron Dorr.
Yeah, if you're in the virtual world and you'd like to testify on this bill, go ahead and raise your hand. Just to give me a sense of the room, if you would like to testify on this bill, raise your hand so that I can allocate time. Okay, let's go ahead and let Mr. Dorr in, please.
Mr. Dorr?
Correct. Has he been admitted? Mr. Dorr, go ahead and light up your camera. Welcome to the House Judiciary Committee. Introduce yourself, and if you represent an organization, please let us know.
Thank you, Mr. Chairman. My name is Aaron Dorr. I'm here on behalf of the Wyoming Gun Owners Organization and the American Firearms Association. Can you hear me okay before I continue?
We can hear you.
Okay, I don't want to drown out the room. Thank you for your time today, members. The bill before you, Senate File 102, is being held up as a Second Amendment Preservation Act in line with what's passed in different states in the last 12 months since Joe Biden's admission into the White House. But I want to be very clear on this. On behalf of the members of Wyoming gun owners, we do not consider this to be a Second Amendment Preservation Act bill. What SAPA legislation in other states is designed to do is give the enforcement mechanism to the hands of we the people. So in Missouri, who enacted this legislation last year, for example, if a governmental agency violates SAPA legislation, the people have the right to take that agency into court for any violation of SEPA law. It's a civil penalty, to be sure, not a criminal charge. But what that does is give the people the actual enforcement tools that they need to hold their own government accountable if they violate SEPA law. What this bill does, Senate File 102, is the exact opposite of that. It leaves the enforcement of SEPA into the hands of either the Attorney General or perhaps county prosecutors. And our members are very aware of what this means. The reality is that no county attorney, no county prosecutor, and very likely not even the Attorney General would ever bring a sheriff or police chief, their agency, into court for a SEPA violation. It's just not politically feasible, and it's just simply not going to happen. And so by removing the citizen enforcement portions of this bill, what this has become now is a bill that's designed to protect, frankly, the careers of politicians and not gun owners in the state. The language that specifically states it only applies if the monies were originating from the state of Wyoming is another gigantic carve-out that our members are very concerned about. What ordinarily happens in these situations is a federal task force, as you heard earlier in this testimony. That's exactly our concern. What we don't want to see is the ATF come into Wyoming, contact the Cheyenne PD and grab some officers there and some deputies over here and some troopers over here and assemble that kind of a joint federal task force to enforce federal gun control laws. This bill was written specifically to not have any problem with that kind of situation taking place. You know, I guess there's been some addressments made in today's amendment on the penalty sections. I won't comment on that. But at the end of the day, when this bill took the other version of SEPA and took out that entire citizen enforcement and let that lie with the hands of county prosecutors, it maintained the label, the name of SEPA, but that's about it. And there's been lots of articles on this. The 10th Amendment Center has done a big write-up on this and compared the other versions of SEPA versus Senate File 102, and have called it a very worthless bill, was their conclusion, not mine. So on behalf of the members of Wyoming gun owners, we're very opposed to our gun rights being used in a way that looks like campaign fodder for election time. We know why this is being done. Our members spoke loudly in 2020 in various campaigns across the state, and they're not going to be happy to see SEPA be hybridized into a bill here that provides protection for politicians and not our members. Thank you for your time. I'm happy to answer any questions.
Committee, questions for Mr. Dorr, Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Thank you, Mr. Dorr, for being here. I appreciate your testimony.
Thank
and
you.
Your willingness to be engaged in this bill.
Sorry, Mr. Dorr, you will address the chair when you wish to speak.
Thank you, Mr. Chair.
Please proceed, Representative.
Mr. Chairman, Mr. Dorr, continuing on, you mentioned your membership, and I'm just curious how widespread that is. Do you have representation in each county? And are we talking like hundreds of members or thousands of members?
Oh, we have members. Thank you, Mr. Chairman.
Please.
Thank you, Mr. Chairman, for the question.
Mr. Dorr, just give me just a second to call on you. Sorry, we just got to get how the back and forth here works. Mr.
Sure.
Dorr, please.
Thank you, Mr. Chairman and members, for the question. We have members all across the state, into the thousands. I wouldn't be prepared to or be inclined to discuss the exact numbers, but they were sufficient to send a loud message in the primary and general election cycle last year, as many former members of the legislature could attest.
Follow up, Representative? Representative Yin?
Thank you, Mr. Chairman. Mr. Dorr, can I just ask where you live?
Mr. Dorr?
Yes, absolutely. I'm a multi-state lobbyist. I live in New York State, and today I'm in the Capitol in Missouri testifying on behalf of gun bills here for the American Firearms Association members in Missouri. Thank you.
Committee, additional questions for Mr. Dorr? Mr. Dorr, do you agree with the language in subsection A of this bill on page 3 that states that the state and political subdivisions shall be prohibited from enforcing, administering, or cooperating with any unconstitutional act that infringes on or impedes the free exercise of individual rights guaranteed under the Second Amendment of the U.S. Constitution?
Mr. Chairman, thank you for the question. I don't have the language at my fingertips, but in general, we agree with any language that would preclude state authorities from enforcing or being compelled, especially to enforce federal gun control. Our issue is with the enforcement, or in this case, the lack thereof, when it comes to citizen enforcement, to be clear.
Committee? Any other questions for Mr. Dorr? Anything else, Mr. Dorr?
No, thank you for your time, Mr. Chairman.
All right, thank you. Carol, other hands that we have raised?
Alan Thompson, Liz Prax, and Jeff Carmichael.
Let's go ahead and admit Ms. Prax, please. Welcome, Ms. Prax. Please introduce yourself to the committee. If you represent an organization, please let us know that organization's name and then let us know what you would like us to hear.
Thank you, Mr. Chairman, and thank you, members of the committee, for your time. I am a Wyomingite. I'm not here to represent any organization other than my family. My name is Liz Prax. My husband and I are responsible gun owners. We support the Second Amendment, but we believe SF 102 will jeopardize rather than protect it. When I was growing up, 2 teenage boys close to my family were killed by gun violence. One shot himself with his father's gun. The other was killed in a stupid argument in a donut shop. Both of them might have been saved by stronger gun safety laws that SF 102 could block. This bill opens the door to extreme interpretations of the Second Amendment that could prevent reasonable gun safety laws from being enforced in our state. The first 4 words of the Second Amendment read, "a well-regulated militia." Our founders fully endorsed the idea of regulation, and they were right to do so. Clear evidence shows that common sense gun regulations, such as background checks, save innocent lives. We have some of the weakest gun laws, both as a country and a state. That's why America has 10 times more gun deaths than other high-income countries. And Wyoming has nearly 3 times more gun deaths than states with stronger gun laws. But guns aren't just used to do harm. They're used to threaten and intimidate. We need to reverse these trends, not just to save lives, but to prove to our fellow citizens that the Second Amendment does not have to infringe on other constitutionally protected rights to free speech, life, liberty, and the pursuit of happiness. To do this, we must support and encourage our police to enforce all gun safety measures, federal or otherwise, to the fullest extent possible. These laws can help to keep deadly weapons out of the hands of violent and mentally ill people, and those suffering from passing homicidal or suicidal urges. SF 102 does exactly the opposite. It will make our state vulnerable to more unnecessary gun violence, not less, and will put the Second Amendment in even more jeopardy. Please vote no on this dangerous bill. Thank you for your time.
Thank you, Ms. Prax. Questions for Ms. Prax? All right. Thank you for joining us. Carol, will you please let Mr. Carmichael in? Mr. Carmichael, go ahead and light up your camera. If you'd like to testify, you need to light up your camera. Welcome. Please go ahead and introduce yourself, and if you represent an organization, let us know. And then let us know what you'd like us to hear. Mr. Carmichael, we cannot hear you. And you are, it does not look like you're muted on our end.
Mr. Carmichael, if you'll look at the bottom left hand, I believe, of your monitor, check and see if you're unmuted.
He's unmuted. All right, Mr. Carmichael, while you figure out your technology on your side, we'll circle back to you. So when we'll just have to circle back to you. Let's go to the room. Mr. Mark Jones. Welcome.
My name is Mark Jones. I am a national director with Gun Owners of America. We're a national Second Amendment rights group that represents 2 million gun owners. And I also live in Johnson County, Wyoming. So I can speak to this bill both as a representative of Gun Owners of America and as a citizen of the state of Wyoming. As we all know, Wyoming citizens cherish our right to keep and bear arms. Sadly, this right is under attack every day by an out of control federal government. Our organization fights in the courts and in the halls of Congress in Washington to try to protect the Second Amendment rights of all Americans. However, a state can, as has been explained by Senator Hicks, provide an additional layer of protection between an out of control federal government and the citizens of the state. This concept of the Second Amendment Protection Act has been adopted by about 10 states, to the best of my ability, depending on what you call an act and what you don't. And essentially, this concept makes it illegal for a state to use its officials to enforce unconstitutional gun control. As Senator Hicks explained, these principles are upheld in the 10th Amendment to the Constitution and also have been upheld 4 times by the Supreme Court using Anti-Commandeering Doctrine. And I'll address some comments made earlier about the different bills. Obviously, there were 2 bills that were introduced. A lot of people on this committee and that have supporters of the current bill voted for both bills. And I want to make it clear, if you look at the nation, there are 2 different ways to approach a Second Amendment Protection Act. The Missouri approach, which Senate Bill or Senate File 87 tried to copy, and it didn't copy it exactly, tried to copy, allows the citizen to use a civil path to sue a department. There are other states that have taken another approach that includes a criminal penalty like found in Senate File 102. So I want to make it clear, there are 2 approaches that have been used in the United States. Which one is best? I don't think we fully know till they work their way through the courts. I will say that our organization, Gun Owners of America, has filed an amicus brief to support and try to defend Missouri in their court battles. We support both approaches. I want to make that clear. But here we are today on the first day of March 2020 in Wyoming in this hearing, and we only have 1 bill. So I think we should all get behind the one that we have, move it forward to try to provide the protections that we can to the citizens of Wyoming. We support the bill in its current form. We oppose any effort to weaken the bill. And we encourage you to please support this bill, move it forward. I want to thank you very much for your time and your effort, and I would be happy to answer any questions if you have them.
Committee, questions for Mr. Jones? Vice Chairman Washut, please.
Thank you, Mr. Chairman. Mr. Jones, appreciate you being here today. We heard some testimony a little bit ago about prosecutors being unwilling to pursue such cases against their peace officers. Any experience nationwide and whether that holds water is a concern or not?
Mr. Jones.
Mr. Chairman, to my knowledge, there have not been prosecutions under SAPAs under either approach. There has been evidence that both approaches have deterred some unconstitutional efforts. So, and I'm talking about draconian things like red flagging veterans in some Western states where sheriffs said, no, we're not going to do it. it's not constitutional. It's not in the law. So, but I'm not aware of any cases to test your theory, sir.
Representative Yin.
Mr. Chairman, thank you. Mr. Jones, is it?
Yes, may I address?
Saw the hesitation.
I'm
there.
sorry, sir.
Thank you. Yes, Mr. Jones is
Sorry,
correct.
my apologies for
Representative
not.
Yin, please proceed.
Thank you, Mr. Chairman. My apologies for not writing your name down. That's usually best procedure for me as well that I neglected. Mr. Jones, so I'm glad that you are a citizen of Wyoming, so you can answer this as a resident of Wyoming. Do you believe the Second Amendment is under attack in Wyoming?
Mr. Jones.
Mr. Chairman, I do believe the Second Amendment is under attack throughout the country. And I work for an organization that represents 2 million members and supporters, and we see it with attempts by the Biden administration to pass executive orders and to force things on the citizens of the United States that they cannot do through Congress. So yes, we could see a situation any moment where our sheriffs and police officers are put in a very hard position. And I think this bill helps them, because I believe most of them want to protect their citizens' rights. They take an oath to the Constitution. And I think this bill helps strengthen their position. But, the state is serving as a barrier, which is perfectly legitimate under the 10th Amendment. The state is serving as a barrier between the federal government and the people.
Committee, additional questions? Mr. Jones, always appreciate a Wyomingite standing up for the Second Amendment and continuing to fight that battle in Wyoming. Thank you.
Thank you, Mr. Chairman and committee.
Is Mr. Carmichael back, or did we lose him? Okay, let's try again, Mr. Carmichael. Oh, it is not your day, Mr. Carmichael. I am sorry, but we cannot hear you. Let's go to the room. Mr. Cole.
Mr. Chairman, members of the committee, my name is Nephi Cole. I'm the Director of Government Relations and State Affairs for the National Shooting Sports Foundation. We represent 9,000 companies that manufacture firearms, accessory, ammunition, optics. I live in Wyoming. I'm very proud to be a Wyoming citizen and a United States citizen. There are hundreds of thousands of Americans that work for our companies, and in Wyoming, thousands of Wyomingites work for companies that are directly affiliated with the National Shooting Sports Foundation. I would like to talk a little bit about one of them is Magpul. And you all may know Magpul. Magpul is the world's leading manufacturer and distributor of firearms, accessories, and magazines. And so that's a unique thing that Wyoming has. We are the #1 location in the world for magazines. I bring that up because we think that this is a great bill. We think that it is extremely important to help provide a space for state and local law enforcement where we're not asking them to implement laws that may be what I'd like to call in the gray area in terms of firearms and ammunition regulation. So one of the things that we noted with this bill is it's in its current format, it talks about protection of the Second Amendment. However, in the heading of the bill, it talks simply about firearms. We'd like to note for you that ammunition and accessories have been regulated and are being regulated at a pretty high frequency. That's not a firearm. So when I talk about a 30-round magazine, I'm not talking about a firearm. I'm talking about a necessary component to make a firearm work, but is not a firearm. So that's a real issue we have. In fact, Magpul is facing that issue in numerous states. For example, the state of Washington, where they're proposing a 30-round, or we call them a standard capacity because it comes with every firearm sold in America, but a standard capacity magazine ban in that state. We see the same thing in states like California. We believe that ultimately that those bans will be shown to be unconstitutional in nature. Why? Because these are things in common use. There are over 20 million of these 30-round magazines in the United States of America today. They are in common use, but the verdict is out right now on whether or not those things are unconstitutional. And so in a scenario where a law enforcement officer was tasked with implementing that type of a regulation from a national level, we believe that that's a gray area. There's another one I'd like to bring up as an example that's a real example that affected Wyoming to let you know why this is important. In late 2014, there was a proposal from the Bureau of Alcohol, Tobacco, and Firearms to ban a bullet. The bullet's called the M855. That followed a successful ban that went, nobody saw this ban coming, but it was on the 7N6 5.45 by 39 rounds. It's a Russian manufactured round that's used in common sporting rifles in America. Nobody noticed when ATF decided that bullet could not be sold in the United States of America anymore. However, people noticed when ATF proposed the ban of the M855. Why? The M855 is a common .223 caliber round. It's one of the most common bullets sold in America today for America's most popular and common rifle, the AR-15. So if that ban would have gone into effect, it would have made the most common bullet, one of the most common bullets for one of the most common firearms in America, illegal. That act, of course, would have been challenged as being unconstitutional, but it could have put Wyoming citizens, anybody in possession of M855 ammo, which if you own an AR style rifle, you've probably got a few boxes of it because it's the cheapest stuff you can find on any shelf in America. It would have made that illegal. We think it's important that you look at opportunities to make sure that Wyoming law enforcement officers aren't put in this gray area of trying to interpret what may be entirely subjective regulations that are coming down. So thank you for considering this legislation. We support it, and we thank you for providing hopefully guidance that this is bigger than just a firearm, but this includes the whole gamut of tools that should be protected by the Second Amendment. Thank you.
Mr. Colin, you've provided us with language that would effectuate this amendment that you're speaking about to include ammunition, grips, et cetera.
Mr. Chairman, I have provided some that I think would address it. And I think the question comes down to, we believe that the Second Amendment already does protect magazines, accessories, and ammunition. And I believe that it's called Section A of this bill accurately says, talks about the Second Amendment. However, in the header of the bill where it lists this as, if you will, firearms, I think that there is an opportunity, if it were considered appropriate and the legislature felt that that should be the intent, to list not only firearms, but firearms, accessories, ammunition, and whatnot in the header to make it clear that when you're talking about the Second Amendment in this bill, you are talking about more than just firearms. And so respectfully, I don't know this process as well as the committee. And so if the legislature feels that is an appropriate amendment, we would certainly support it.
Questions for Mr. Cole? Thank you, Mr. Cole. Ladies, were you wishing to testify on this bill? Please come on up.
Thank you, Chair Olson and committee members. Thank you for the opportunity to speak today. I am Beth Howard. I'm a volunteer with Wyoming Moms Demand Action for Gun Sense in America. 3 generations of my family live here in Cheyenne, and I am interested in protecting their health and safety. Senate File 102, the Second Amendment Protection Act, is unnecessary, potentially dangerous, and I strongly oppose it. There are no federal laws, current or pending, that infringe on a Wyomingite's freedom to own or use a firearm, though I've heard a good deal of speculation on such proposals. In fact, Wyoming has by far the highest number of guns per capita of any state. For Wyoming's 582,233 citizens, there are 132,806 registered firearms, and who even knows how many unregistered guns? The bill will cause confusion and undermine the rule of law. It will encourage extremists to not enforce federal laws that they personally disagree with. And further, it may cause violent criminals and other people legally prohibited from having guns to violate the law. The distinction of ensuring that the state is prohibited from enforcing any unconstitutional act just makes this even more of a grandstanding type of bill and would depend on what is deemed constitutional. With this bill, we appear to have once again a solution looking for a problem. I recognize that 2 committee members are co-sponsors of this bill, but respectfully request that all of you please vote no on Senate File 102. Thank you, and I would stand for any questions.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Thank you, Mrs. Howard, for being here and for being engaged. I too am a mom and also a gun owner, and I'm just curious if you could tell me what exactly the mission or vision of your organization that you represent is. Thank you.
Ms. Howard.
Thank you, Chair Olson and Representative Rodriguez-Williams. One of the primary goals of our organization is to prevent firearm homicide and firearm suicide. Wyoming is now #1. Again, the worst thing we can claim to #1 in suicide rates, but also I think 70% at least of those deaths are firearm suicide. We want more people to live. I am pro Second Amendment. I have 2 sons who have served in the military. I have an active duty Marine working at the Pentagon and has been deployed to Afghanistan 3 times. I have an Army veteran who has been deployed to Iraq. And so my family are firearms owners. I just am in favor of keeping people safe, and this bill does not do that.
Committee, additional questions? Ms. Howard, thank you for your testimony.
Thank you.
Carol, I believe we have a phone caller who would like to testify. Can we go ahead?
He has left.
He's left.
We have Alan Thompson and we have Dwayne Pacheco.
Mhm.
Oh, the phone number. Oh, the phone just came back on.
Okay. Let's give that one a shot. Unfortunately, we can't chat with a landline, so we don't know who this landline is, but we know that the landline would like to testify, and we would like to hear them.
Can you hear me?
We can hear you, yes. Go ahead and introduce yourself, and if you represent an organization, let us know, and then please feel free to share your testimony with us.
Thank you very much for your patience, Mr. Chairman. My name is Jeff Carmichael. I live in Johnson County. I'm sorry for the earlier technical problems on my end, apparently. I appreciate the opportunity to speak to you today about this bill. I believe this bill to be a good bill, a strong bill that does what it needs to do, which is to protect my Second Amendment rights against never-ending federal overreach and bills that would infringe on my rights. I also want to take the opportunity to say that I don't think this bill is about gun safety, but it's about my gun rights. And the Second Amendment says my gun rights shall not be infringed. Does not say it can be infringed a little bit here and a little bit there until the Second Amendment is meaningless. I'd also like to say that in regards to the Wyoming Gun Owners Association's opposition to the bill, I am a member of the Wyoming Gun Owners Association. I'm also a life member of the NRA and a life member of the GOA. I don't agree with Mr. Doerr, And I think that his efforts are more geared towards fundraising than to actually passing a bill, meaningful legislation, since they bring the same one every year, and it's been universally opposed by law enforcement every time. I think that 102 is a very good bill. I urge the committee to pass it with no weakening amendments, and thank you very much for your time, and I stand for any questions.
Committee questions for Mr. Carmichael? Mr. Carmichael, we're glad that you were able to join us, and even though you had to use an alternative form of technology. We appreciate your willingness to testify and definitely your tenacity and commitment to making sure you got through to us.
Thank you, sir.
All right, Mr. Odekoven.
Thank you, Mr. Chairman. I do my best to go paperless, except on days like today, I seem to bring a lot. Byron Odekoven, the Executive Director for the Wyoming Association of Sheriffs and Chiefs of Police, rising in support of the bill. And let me give you a little background from where we come, both as an association of jointly of sheriffs and chiefs, and myself personally as the Executive Director. Many of you know my background. However, for those on Zoom and online and out and about, I served as the elected sheriff in Campbell County for 16 years and have most recently as the executive director for the association. Over the course of my career and my personal life, I'm a life member of the NRA and also put my money where my mouth was and became not only a benefactor member, but a benevolent member of the NRA as well, which means when they called for additional funds to help with Second Amendment issues, I answered that call and presented them with money to be able to help do that. Now we could talk about where they are doing now, but nonetheless, that was then and here we are. Secondly, in the Senate, we mentioned the Supreme Court case that was cited. Our good Senator Hicks mentioned the 4 cases preceding. Most people don't realize that there were 2 sheriffs that participated nationally in amicus briefs and suit to the federal government as a pushback against the Brady bill, that commandeering that was discussed that happened under the Clinton administration. One was Sheriff Mack out of Arizona. The second was myself on behalf of the state of Wyoming and the sheriffs and chiefs of the state of Wyoming in 1995. Secondly, as well, we published an article when the issue first came out in the Western State Sheriff's magazine titled "Gun Control is Wrong" for Wyoming, authored by Sheriff John By on behalf of sheriffs and chiefs in Wyoming. So we have a long history of supporting constitutional measures as it relates to firearms and pushing back on unconstitutional measures. I want to say thank you to the bringer of the bill. As was mentioned, this was an effort. This was several months worth of discussion to come up with a very clean, simple statement to push back again to the federal government and say that we will not participate in any unconstitutional efforts that would infringe or impede the Second Amendment. I don't know how much stronger we can say that. We've discussed over time lots of amendments, lots of language, lots of suggestions, but at the end of the day, the discussion is the action constitutional or not? Does it impede or infringe or not? And thus the bill is supported by the sheriffs and chiefs. I've presented a statement as well, one from the president of our association, Chief Dwayne Pacheco, the Rock Springs Police Chief, who's joined us on Zoom. We presented the committee with a letter of support for Senate File 102. And likewise, on behalf, and to be clear, 23 sheriffs support Senate File 102 and have also issued a separate letter combined with the sheriff's and chief's letter as a mirror letter that says we support the bill in its current form, without any additional amendments. So, Mr. Chairman, I would like to hear from, if I may, hear from Chief Pacheco and Sheriff Thompson as well.
Carol, those are online. If you would like to please admit Alan Thompson and Dwayne Pacheco.
Mr. Chairman, while we wait for them, if I may, last week during our meeting, we held a meeting, as you know, of sheriffs and chiefs here. We hosted a breakfast. You saw many of the sheriffs and chiefs members. We discussed this bill again. And to reinforce, we said the bill, we support it in its current form, and we would oppose it should it end up with any crazy amendments that happen in the long run. But in its current simple form of stating unconstitutional infringement and impediment, clearly the room supported it, Mr. Chairman.
Vice Chairman Washut has a question for you, Mr. Odokoven.
Thank you, Mr. Chair. Mr. Overcoven, you've heard Mr. Cole's testimony a little bit ago about including firearms, accessories, and ammunition. Would that be an acceptable amendment for your organization?
Mr. Odokoven.
Mr. Chairman, yes, it would. Anything that would provide that level of clarity to ensure that what we are talking about would be constitutional or unconstitutional would be appreciated. Thank you, Mr. Chairman.
Representative Lorson.
Yes, Mr. Chairman, thank you. The Sheriff's Association was against the bill, that SAPA bill that came forward last year. What are the big differences that you make that this bill would get your support?
Mr. Odokoven.
Thank you, Mr. Chairman. The bill last year had a penalty provision that removed qualified immunity from officers for anything related to a firearms bill. I think as you heard testimony then, we talked about how that would impede law enforcement's ability to deal with criminal behavior as it associates with a crime involving a firearm. I believe the example that was used last year, that a bank robber, as long as he presented a bomb at the bank, local law enforcement would be able to investigate. But if he presented with a firearm, based on the unclear language within last year's bill, the question is, could local law enforcement investigate that crime because it involved a firearm? We would be removed from qualified immunity. So any action we took related to that firearm, we could be sued for unquestionably. So yes, we oppose that ambiguous, unclear language as it relates to law enforcement procedure dealing with criminal behavior.
Follow-up, Representative Lorson.
Thank you, Mr. Chairman. Do you see any concerns of local law enforcement doing something out of bounds? Enforcing some executive orders that we don't think are constitutional on Second Amendment on a gun or such, and then their local attorney having issues where they aren't going to, bring a suit or anything because they have to work with them every day and relationships are broken.
Mr. Odokoven.
Thank you, Mr. Chairman. I think I'll start by saying we all took an oath to uphold the Constitution, the laws of the United States, and the laws of the state of Wyoming. So I do not see where a local officer would somehow decide to enforce an unconstitutional executive officer, and how we would have a local prosecutor somehow decide that that would be okay to somehow enforce an unlawful executive order. So no, Mr. Chairman, I don't see that happening in the state of Wyoming.
Representative Provenza.
Thank you, Mr. Chairman. Thank you, Mr. Odokoven, for being here. One of the questions I have, because it sounds like, what is unconstitutional or not will be kind of determined by either the agency or the officer. And I'm wondering, how often do officers have to take constitutional law like courses to or to understand like what is and what isn't. Thank you.
Mr. Odekoven.
Thank you, Mr. Chairman. So unconstitutional law is taught to every officer at the Law Enforcement Academy going in. And every year, we generally, most agencies have a update, constitutional law, laws of Wyoming, federal court cases update during the month of May, is what many agencies do across the state. So any changes in law that would pertain to officer activity are addressed for sure at that time, as well as sheriffs and chiefs are sensitive to changes ongoing to make sure that policy and procedure directions for the agency are timely to the change in the law and changes that they need to be aware of in order to properly execute the duties of their office. I would like to touch that question does hinge on an earlier question that talks about the receiving of federal funds. And I think that what the on page 3, line 18 is attempting to discuss are those funds that we receive during the normal course. So whether that's the COPS funds for the hiring of additional officers, for the purchase of a canine, bomb techs, et cetera, that this bill would clearly not impede what has been happening in terms of the normal funds that are received through the governmental budgetary process that then feeds to a local agency.
Representative Larson.
Yes, Mr. Chairman, thank you. That when he brought that up, it just fired me up. So if you get dollars from the government, are there regulations and rules that you've agreed to that anytime they want to come in and have help enforcing something, is it an obligation for the local sheriff or whatever to do such?
Mr. Odekoven.
Mr. Chairman, no, sir. The regulations that generally come with those funds are talking about the length of employment. That you would have that officer, you'd hire that officer, but then you would retain that officer over a period of time. It does not come with any regulations that we would go forth and help on any other matters.
Oh, sorry, Representative Yin. Go ahead.
Mr. Chairman, thank you, Mr. Odekoven. So I know you mentioned in the very beginning that you already, that the Wyoming Association of Sheriffs and Chiefs of Police already pushed back against federal unconstitutional laws. So do you believe you are doing the best to fight against federal overreach when it comes to Second Amendment?
Mr. Odekoven.
Mr. Chairman,
if you can.
Not quite, I didn't quite track where I needed to go with the answer there, sir.
Mr. Chairman, if I may. Yeah, so I did kind of go over my words there. So do you believe, one of the proponents of the bill said that this provides a shield, an extra shield where the state can protect against unconstitutional gun laws. Do you believe that your association is already doing that? Protecting against unconstitutional gun laws based on your testimony today, Mr. Chairman?
Mr. Odekoven.
Mr. Chairman, I believe the answer is yes. So let me reframe my question / answer. So I believe the question is, are we as Wyoming law enforcement prepared and already protecting against unconstitutional firearms laws? I would say the answer is yes. I don't see a situation where we would go forth and do something that is unconstitutional at this point, with or without this bill.
Bring in Mr. Thompson. Senator James, I've never been into the full offer postman. I just have to say, pull it off. My wife welcome Alan Thompson and Chief Checko in any order. Or draw straws. Chief Pacheco, can you hear us? Chief Pacheco? Welcome.
Yes, Mr. Chairman.
Go ahead and introduce yourself. And if you have any comments for us, we'd love to hear from you.
Thank you, Mr. Chairman and committee members. Good afternoon. I'm Rock Springs Police Chief Dwayne Pacheco. I'm the president of the Wyoming Association of Sheriffs and Chiefs of Police, and it's my pleasure to address this committee regarding our support of this bill. I have 31 years of law enforcement experience, all with the Rock Springs Police Department. I'm also a retired veteran of the United States Air Force Reserve. Police chiefs and all 23 sheriffs of our association support this bill. To get all law enforcement executives to agree on one bill can be difficult, but this bill involves the Second Amendment to the United States Constitution, which is near and dear to our hearts. The same Constitution that we raised our hands and swore to uphold. I have my officers raise their hands and recite the oath of honor annually here at the Rock Springs Police Department. This bill has the appropriate penalty to ensure our peace officers never infringe or impede the free exercise of individual rights guaranteed under the Second Amendment to the Constitution. And I would ask that you vote for the bill as written. And I thank you.
Committee, do you have questions for Chief Pacheco? All right, Chief Pacheco, as always, thank you for joining the House Judiciary Committee.
Thank you, Mr. Chairman.
Sheriff Thompson, welcome.
Mr. Chairman, thank you. Can you hear me all right?
Yes, we can.
Thank you for this opportunity. I'll be as brief as possible. I just want to echo Chief Pacheco's statements from earlier. The sheriffs across Wyoming support this bill and support the Second Amendment of the United States. We demonstrate that to our citizenry on a daily basis. And this bill will just kind of codify that for us and help the public better understand the direction that we're obligated to go and that we will go as sheriffs across Wyoming. I did want to address real quick the constitutionality question. As this bill is written, I don't believe that this is going to come down to individual officers or administrators determining what's constitutional. As Senator Hicks referred to in his opening remarks, the constitutionality is something that's decided by the judicial branch. And we stay in tune with not only law changes in Wyoming, but in judicial rulings across the United States, and especially in our circuit court and our Wyoming Supreme Court. So that changes how we do our work on a daily basis. And we will continue to stay abreast of those as law enforcement professionals across Wyoming. And I would be happy to answer any questions you might have. Thank you, Mr. Chairman.
Questions for Sheriff Thompson? All right. And thank you for joining us as well. Did you have a question? Oh, I'm sorry. Anything else, Mr. Odekoven?
Thank you, Mr. Chairman. I would just offer again, thank you to the co-sponsors and the several people that worked with us to come up with a very clean language bill to simply state, as we've all desired, to push back on any unconstitutional efforts to infringe or impede our Second Amendment rights. Mr. Chairman.
That reminds me, Mr. Odekoven, I wanted to thank you for that, your work on that 1995 brief. I recall studying that in law school and the backwardsness of the Ninth Circuit's decision. So I appreciate you not only fighting for gun rights here in Wyoming, but on the national stage as well.
Thank you, Mr. Chairman.
Anyone else in the virtual world who wishes to testify on this bill? Is there anyone else in the room who wishes to testify on this bill? Miss Muir, come on up. Go ahead, Mr. Winnie, have a seat. I'll give you each, I did say I wanted to be done at 1:50. So give you real brief comments if you please.
Mr. Chairman, Bill Winnie, Sublette County. I thought this would come up, but it didn't. One of the things I think is germane to your thinking is there was a U.S. Supreme Court decision some years ago about the chief law enforcement officer, which requires federal authorities to coordinate with, check in with, and even be subject to the direction of the local sheriff. Subject to your questions. Thank you.
Questions for Mr. Winnie? Thank you, Mr. Winnie. Ms. Muir? Same directive, please.
Thank you, Chairman Olson and committee members. I'll try and summarize, had lots of stats to give you. We understand, I'm Tara Muir, the Public Policy Director with the Domestic Violence Coalition Against Domestic Violence and Sexual Assault. We have concerns with this kind of bill. I think the amendment that inserted the word unconstitutional helps, because some of the most dangerous things that can happen for particularly intimate partners and females in particular in domestic violence situation is if there is a firearm in the home. 5 times more likely she's going to end up dead than if there wasn't a firearm. We understand there are 2 very specific federal prohibitions laws that probably aren't included in this bill because of that word unconstitutional. They're ruled constitutional, but I think we've still got a long way to go to find out if this, because we know from our programs across the state, confiscating firearms when you're subject to a protection order or if someone's been convicted is inconsistent across the state. Whether that's just a matter of resources, it's a tremendous concern, and we'd like to at some point have that discussed as well when there's time. Happy to answer any questions.
And Ms. Muir, please feel free to forward us those statistics that you would like us to see. We would love to look at them.
Thank you, Mr.
And I
Chairman.
do
will.
apologize on the timing. We do have a special ceremony today in the chamber, and I want to be respectful of that ceremony. Any questions for Ms. Muir? Thank you. Anyone else wishing to testify on this bill? Anyone else wishing to testify on this bill? All right, I will close public comment on this bill. Committee, what is your pleasure?
Mr. Chairman, can I move Senate File 102?
Senate File 102 is moved by Representative Zwanitzer, seconded by Representative Oakley. Do you have any amendments on this bill? Amendment by Representative Washit.
Thank you, Mr. Chairman. I'd just like to introduce the amendment referenced by Mr. Cole on page 1, line 1, after the word firearms. We would insert a comma and then the words firearm accessories, comma, magazines, and ammunition. And the same language would be inserted after the word firearms on page 2, line 22.
Second.
Moved by Representative Washit and seconded by Representative Zwanitzer. Carol, do you have that amendment? Excellent. Committee, do you understand the amendment? Do you have questions on the amendment or discussion on the amendment? All those in favor signify by saying aye.
Aye.
All those opposed? That amendment is adopted. Additional amendments? Vice Chairman Washit or Representative Oakley?
Thank you, Mr. Chair. We were provided a proposed amendment and that was discussed by Senator Hicks as far as switching the word servant to officer, and it's all been provided. So I would move that amendment.
Okay, the proposed Senate file amendment to 102-1, which is an LSO amendment, which Carol, you do have. Moved by Representative Oakley, seconded by Vice Chairman Washit. Discussion on the amendment? Question on the amendment? All those in favor signify by saying aye.
Aye.
All those opposed? That amendment is adopted. Any other amendments on this bill? Discussion on this bill? Question being called on this bill? Carol, will you please do a roll call vote, on Senate File 102, Second Amendment Protection Act?
Representative Crago,
Aye.
Representative Larson,
No.
Representative Oakley,
Aye.
Representative Provenza,
No.
Representative Rodriguez Williams,
Aye.
Vice Chair Washit, Representative Yen, Representative Zwanitzer, Chairman Olson.
Aye.
1, 2, 3. 6 ayes, 3 noes with amendments.
All right, thank you for joining us today. Thank you for your testimony, and we are adjourned and just in time for that ceremony. Sure.